I beg to mention, my lord, item 11 and 12, my lord. These are service matters, my lord, of 2020. And twice over the matter came before the court of the Honorable Chief Justice. So I guess, my lord, this matter is not as per roster listed in this court. It's wrongly listed, my lord. 11 and 12, my lord. Service matter of 2020.
The matter came before the...
Yes, my lord, twice over.
Then why he has come back now?
My lord, it's a mistake, my lord.
I have no idea, Your Lordship.
Because the roster is also very clear, my lord.
What do we do?
It can be taken up by the court also, or I have no issue, Your Lordship. Either by the court or by the Honorable Chief also, I have no
We
issue.
don't know what was the last order pass.
The last order only says list on so and so. By the Honorable Chief Justice. It does not say, my lord, before another bench. This is dated 20th of March 2020.
What we'll do is, we will check
Yes,
with
my lord.
the registry. We'll just
Deferred
pass
for
over
today.
the matter.
Lordship, yes.
List this matter up to, on submission made by parties, list this matter up to
2 weeks.
2 weeks.
Apply.
11, 12.
Apply, Your Lord.
May I please, Your Lordship, I beg to mention item number 9. I am appearing on behalf of the respondent number 4, Your Lordship. Your Lordship, I humbly pray to let this matter be taken up after 2 weeks.
Why?
We are not ready, Your Lordship, as we need to do some research.
What was the last order passed, Mr.
Last order, they saw determined the matter was supposed to be listed for 2 weeks. After 2 weeks, Your Lordship.
I recall. 2018 matter, you cannot just go on like this.
Pardon, Your Lordship?
It's a 2018 matter.
Yes, Your Lordship.
You cannot just ask for time, from time to time. In fact, I believe, if I'm not mistaken, this matter was heard.
Yes, Your Lordship. That was, however, last year, in the month of March.
So, submission of the petitioner was heard, or both
My
parties.
submission was actually heard, Your Lordship, but the other party, the other side has not been heard.
Okay.
Perhaps the court may require to refresh again, Your Lordship. It can be taken up in the next stage, Your Lordship.
You're for respondent?
Number 4, Your Lordship.
On premium by the respondent number 4, seeking accommodation on the ground of the indisposition of the Learned Conducting Council, matter not being objected to by the petitioner, that is, list this matter up to 2 weeks.
Please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. Item number 10.
First state, my lord. No objections, man.
Why?
Some accommodation, Your Lordship, needed to be sought.
You've been seeking time again and again in this matter.
Yes, Your Lordship.
You're not interested in the case?
Your Lordship, some accommodation, Your Lordship, needed to be sought in this matter.
On premium by the petitioner, not objected to by state respondent, that is adjourned. List the same after 2 weeks.
I'm ready.
To be obliged, Your Lordship.
I beg to make a mention of item 5, my lord. If it is taken up after 3 weeks, my lord, because in the meantime the other matter
also is still pending, Your Lordship.
Or that
Yes.
on premium by the parties, list this matter up to 3 weeks.
Highly obliged, Your Lordship.
I should forget to mention item 15.
This is that check gate matter, Lordship, District Council. So, it requires some time, Lordship.
You've got an interim order in your favor.
It is an interim order, Lordship. Lordship, in fact, during the pendency, there was another writ petition which was traveled up to division bench that has also been disposed of just recently regarding the Kletershi check gate, Lordship.
Okay. Excuse me. On primary petitioner, this is matter to 2 weeks.
Right, Lordship.
From daily list, item number 1.
Okay, about the generals now.
Yes, Mr. General.
Yes, Your Lordship, on the last occasion, Your Lordship have directed for the case record to be brought
No,
for Your Lordship's perusal.
what is your case?
This is the bail application that I've moved, Your Lordship, and the main grounds that the prosecution, Your Lordship. In this instant case, I've just relied on the CDR, the call detail record, to arrest me in the matter, along with other co-accused persons. From the from the vehicle, the contraband was not seized from me. The vehicle does not belong to me. I'm just a passenger in the vehicle. It is on record that the vehicle belonged to the other co-accused, and even the.
It's a public.
No, it's a yes, it's a public transport. It's a public transport.
You are just a passenger.
I'm a passenger in the vehicle. The driver is known to me, no doubt about that, and he's hailing from same region, Manipur, and I have booked the vehicle actually to proceed to Guwahati to meet my family. I've also annexed the school documents of my children to show that they are studying in Assam, Guwahati, Assam, because of the conflict that started in the Manipur last year. So we have shifted temporarily the residence to Assam. So that is the purpose. And at the time of the arrest, just because the contraband was seized from the vehicle, in which I'm also one of the occupant in the vehicle, I've also been made accused. And the only evidence that the prosecution is relying against me is that the call detail records. Just a call history, Your Lordship. On the last date, Your Lordship, I've tried to impress on Your Lordship that simply relying on the CDR without any other substantive evidence, that is not enough to show that on the face of the record at the time of bail, this is a matter under NDPS, Your Lordship, where under Section 37, I just have to impress whether the court shows finds any reasonable ground to believe that I'm not guilty. So, Your Lordship, simply relying on the CDR, saying that it's a call history, that on so and so date I've made a contact with the person, and hence I'm also liable for conspiracy to commit the act, because Section 29 have also been leveled in this case against me. So that is my main argument, Your Lordship. And I've cited some judgment also, Your Lordship, where the same scene set up of a set of facts when it came before the Punjab and Haryana High Court. I've also highlighted that, Your Lordship, on the last date, where it said that the accused, since there is no recording of the conversation in between the accused, mere contacts with the co-accused were found to be in possession cannot be treated as a corroborative material in absence of substantive material found against the accused. So this is also my main contention before Your Lordship. And on Your Lordship, after hearing the parties, Your Lordship, I've asked for the case record to be.
Lordship, we given the case record.
What is your stand?
Lordship, my stand is so far Punjab and Haryana High Court is concerned, Your Lordship. Punjab and Haryana High Court on a factual situation stands in a different premise. It's one of the co-accused was not named. The other co-accused implicates, not named in the FIR. The other co-accused implicates this accused, and it's not in the public transport. So very important situation is not the public transport. So on that context, the CDR detail was relied upon. Now, Lordship, we have got another Supreme Court judgment. I'll just like to rely on it. The last page is irrelevant. Para 34. Para 34. Page.
uh, 2021.
21 Lordship.
Para
Para 34.
Yes.
Lordship, as I submitted, Lordship, this judgment is distinguishable from my learned friend is relying on Punjab and Haryana, but law is settled in the matter of commercial quantity and public transport. So, if I may allow to read, Lordship.
Please.
3.34.1, Your Lordship. The respondents was travelling in a vehicle all the way from Dimapur to Nagaland to Rampur in Uttar Pradesh with the co-accused. Facts are almost same, they're travelling together. The complaint notes that CDR analysis of the mobile number used by the respondent indicates the respondent was in regular touch with the co-accused who were known to him. This is also same, Your Lordship, in touch. The quantity of contraband found in the vehicle is of commercial quantity. Same. The contraband was concealed in the vehicle in which the respondent was travelling with the co-accused. Now, Your Lordship, 31, 1, 2, 3, 4, almost factual situation is same. Only distinguishable in Punjab and Haryana is that the transcript of the call detail, and it was not a public vehicle. It was not an FIR. So, in that factual situation is distinguishable. Now, we come to 35, Your Lordship. The impugn order of the High Court, in this case, Your Lordship, the High Court had granted bail. High Court had granted bail. So, now the Honorable Supreme Court discusses the impugn order of the High Court, apart from observing that no contraband was found from the personal search of respondent, has ignored the above circumstances. The High Court has merely observed that in Mohammed so-and-so, in view of the above, the twin conditions contained under section 31(1)(b) of NDPS stands satisfied. This court is of the view that if there is a reasonable ground, the applicant is entitled to be released on bail. This is the observation, Lordship. The High Court has clearly overlooked crucial requirements and glossed over the circumstances which was material to the issue as to whether a case of grant of bail was established. In failing to do so, the order of the High Court becomes unsustainable. Moreover, it has emerged during the course of hearing that the respondent was enlarged on bail. He was consistently remained away from the criminal trial, resulting in the issuance of non-bailable warrant against him. This is irrelevant. The High Court ought to have given due weight to the seriousness and gravity of crime, which has failed to do. For the above reasons, we allow the appeal and set aside the impugn judgment in order of High Court dated so-and-so in so-and-so. The application for bail filed by the respondent shall stand dismissed. The respondent shall stand forfeit. Pending applications, if any, stand disposed of. See, only one distinguishing factor is that he did not stand for trial, he was absconding. That the High Court did not consider. But Your Lordship, 31, 1, 2, 3, 4, 5 is very relevant for the purpose. These are the conditions, the parameters laid down. The transcript is not, the issue of transcript, which my learned friend is relying, will not be applicable in a public transport. Because there is an additional circumstances. And in a public transport, Lordship is aware that law has been settled by this particular paragraph. That commercial quantity, public transport, CDR detail, what exactly the transcript, if these requirements are fulfilled, and High Court, before High Court, this requirement of 31, 1, 2, 3, 4 was fulfilled, but still it chose to ignore the circumstances. Now we have a situation which complies with 34, 1, 2, 3 and 4. Given this settled set of law, which is material with the case of the friend, my learned friend is making time and again submission that the prosecution is relying only on the CDR detail for filing the charge sheet, and the transcript is not available in the charge sheet. And to justify the non-availability of the transcript for granting on the bail, he is relying on the Punjab and Haryana. So my respectful submission, Lordship, that is distinguishable. Punjabi and Haryana transcript, the factual, here Lordship, the FIR has named both the person. In Punjab, only one accused was named, and the accused implicated the other accused. And in that situation, then the issue was they had a CDR detail, but the actual content of the CDR was not available. So Lordship, that will not be applicable, and since this meets the requirement of 34, my respectful submission, Lordship. So far CDR is concerned, public transport is concerned, commercial quantity is concerned, all the material facts have been laid down, and it's a commercial quantity, Your Lordship. Supreme Court is very clear. No bail should be granted.
What is the stage of the case, you say?
Evidence. It is at the stage of evidence, Your Lordship. Complainant has been examined on the last date.
And how many witnesses are there?
There are nine witnesses.
You've given the case diary, Your Lordship.
I'll peruse the case diary and the authorities cited by the party.
Pleasure.
And one more authorities, if I can place, Your Lordship, which says that with regard to the details and charts, it is to be tested during trial. This particular judgments. Para 25. Para 25 of that judgment.
How will this help your case?
Which says that with regard to call details and charts, it is a matter of trial. So at that stage of bail, Your Lordship.
That is always there.
Yes, yes. Just to further.
Not necessary to be.
That is 2023.
2023?
Oh, no. This is 2021. SEC online.
And para?
25, Your Lordship.
25.
Delhi High Court.
The last 2 lines. 2-3 lines.
Basically, suppose the prosecution case only.
Passes the order. Let me go through the.
Yes,
series.
Much obliged, Your Lordship.
Item number 2.
Please, Your Lordship. Lordship, 4 matters are shown in the list. But as I've been submitting all along, Your Lordship, all these matters stand on their own merits and it is not similar, Your Lordship.
We'll hear it one at a time.
Lordship, that's what I'm trying to do. So I'm arguing WPC number 45 of 2015 now, Lordship.
Please.
May it please, Your Lordship. Lordship, in brief, Your Lordship, if I may just place before Your Lordship. This is with regard to the financial upgradations which are made available to NEHU employees, Your Lordship, as these are posts where there is no scope for promotion. To compensate for that, Your Lordship, this financial upgradations are given as an incentive to the petitioner also, Your Lordship.
That was before the SCP scheme and the MSCP scheme was,
Lordship, this is the incentive is because these posts, Lordship, they don't have any promotional avenue. So because people will be stagnating in one particular post for almost 30 years or more till they retire, so to give an incentive to the employees, Your Lordship, this financial upgradations are provided. So, as Your Lordship is fully aware that there are 3 upgradations here which we are concerned with. The first one is that one time which is called autumn, which is given after 8 years. The second was that ACP, which is available after 12 years. And the third is MACP, that is modified ACP, that is after 10 years. So, these are the 3 upgradations which is made available to any employee serving in these kind of posts. This person, Your Lordship, he was serving as a stenographer and he was appointed in the year, the date of appointment is 6/3/86.
6/3/86. Stenographer.
Lordship, I'll give the brief crux of the matter, and then I'll go to the, because these are all facts and figures only which your Lordship will look into. So, as per this, your Lordship, if he's joined in 86, his 8 years is completed on 6/3/94. So, he's entitled to the first benefit under autumn, in which he got. After 8 years, Lordship, on 6/3/94, he has got the benefit which is given under autumn. Now, the next benefit becomes due to him under ACP, your Lordship, which is after 12 years from 94. So, from 12 years from 94 is 2006 year. 94, 2004, 6, so that's 12 years. So, his ACP is due on 6/3/2006. Lordship will kindly just take note of this date because this is pertinent, your Lordship. 6/3/2006.
That is counting from 1994.
Yes. Lordship, autumn he has got on 6/3/94.
Yes.
Exactly after 8 years, as was due to him.
Yes. Yes. Then 6/3/2006
2006, Lordship, it is 12 years after 94.
ACP.
ACP. Even this he has got, your Lordship. Now, as per the 6th CPC, your Lordship, which was prevailing, Lordship, he was getting a pay scale of 6,500, 10,500 at that point of time.
That is on 6/3/2006.
6/3/2006.
Pay scale was
6,500, 10,500.
Yes, please.
Lordship, thereafter, so this also after 12 years he has got, your Lordship. His ACP has got after 12 years. But what he was getting, Lordship, was 6,500, 10,500. I'll come to this. Then comes MACP, Lordship, the third upgradation. That comes after 12 years from ACP. So that is due, Lordship, from 6/3/2006 after 12 years.
Is it 12 years or 10 years?
Lordship?
MACP is 10.
MACP is 10 years. So after 10 years, so he's due to get on 6/3/16, your Lordship. 6/3/2006, he gets his second under ACP. And 6/3/16, after 10 years, he's supposed to get his MACP. Now he has got that also.
Yes.
Here is a case, your Lordship, that our grievance is not that we have not got the financial upgradations that we are entitled to under autumn ACP and MACP. I've got all the three. My case, your Lordship, is that what I am due to get, I have not got. Now, MACP comes into effect from 1/9/2008 with retrospective effect from 1/1/2006. Lordship, this date is pertinent. The MACP is effective from 1/1/2006. So if it is effective from 1/1/2006, whatever is the fixed scale as per that, your Lordship, I will be entitled to. But before I come to that, your Lordship, I'll just explain this part. Before I come to that, your Lordship, meanwhile, your Lordship, the 6th CPC came into effect. It came into effect from 2006. The 6th CPC. And when 6th CPC came into effect, your Lordship, the 3 pay scales, Lordship will kindly remember, there were 3 pay scales which were clubbed together and put together in a particular grade. So all these three pay scales clubbed together and put under PB to your lordship. So as I have submitted your lordship, I was getting 6,500, 10,500. So this scale is also merged with this other two, your lordship. That is, the three scales which are merged, lordship, will kindly note. One is 5,000, 8,000. One is 5,500, 9,000. And the third one is 6,500, 10,000. These three pay scales are merged into one grade. It becomes a common grade. Am I clear, your lordship, so far? So since I came under the third one, 6,500, 10,500, I have been merged. I have been merged with the other two and put in a particular grade. Now your lordship will see that when employees, somebody who has been receiving 5,000 and somebody who's receiving 5,500 and some, if all the three are clubbed together, the people who are lower will get more benefit, whereas the higher one is being put together at the same level with a lower guy. So there is sometimes, because everybody feels that somebody who was lower to me in a lower pay scale, now because of this we've been clubbed together and put in a same grade, and I'll be getting that same pay. Now to resolve that, your lordship, the Government of India came up with this order dated 9/7/2010. Lordship, I'm not referring to the relevant annexures at this point, just to give your lordship a brief overview of the whole matter. So to club all that, this was resolved by this notification, which was also approved by NEHU by its order dated 30/10/2012. All this is on record. So when this was resolved, lordship, there were two scales. One is 4200 and 4800. So I was put in the 4800 grade, your lordship. So when I got my third MACP, your lordship, in 6/3/2016, I was given this case scale of 4800. Am I clear so far, your lordship? Now, my entire grievance, your lordship, is that the first grievance, there are two legs, two grievances I have. Lordship, when the fifth CPC came into effect, when the fifth CPC was in operation, I was getting 6,500, 10,500. And so when I was given my second upgradation under ACP on 6/3/2006, lordship, I continued to receive this 6,500, 10,000. That is the notification, the order which was issued is here, your lordship. But with the sixth pay revision, your lordship, which was given retrospective effect, the sixth pay commission, which came into effect from 1/9/2008 with retrospective effect from 1/1/2006, lordship. So from 1/1/2006, lordship, I am entitled to get what is to be given under the sixth CPC, your lordship. Am I clear, your lordship, to that extent? So if I'm entitled to get what is provided under 6 CPC, lordship, then I should be given that what is provided and not what I was given, your lordship.
What was provided under 6 CPC?
Lordship, under 6 CPC, the pay scales were different, your lordship. As I have said, that those three were clubbed together. So this 4800, your lordship, has come into effect from 1/1/2006, that retrospective date. Whereas I continue to get that other pay scale, lordship. And because of that other pay scale, I was receiving 4200. So, lordship, my whole contention is that this 4800 has been given to me only when I got my third MSCP. That is on 6/3/16. My contention in Lordship is that I should get this figure of 4800 from 6/3/2006 when I came under the ACP, Lordship. Should I clarify this?
That's okay. It's understood. It's understood.
Lordship.
The fact is that now, what you are drawing now
Lordship.
is that 66500 or 4800.
No, Lordship.
Under the-
First of all, now I've already retired.
The relevant point of time.
I've retired. So I'll just explain this part, Your Lordship. I became, because all these figures are sometimes very confusing. So just for my own satisfaction, may I just reiterate, Lordship? Lordship, this MECP came into effect with retrospective effect from 1/1/2006. So these rates become applicable from 1/1/2006. But if I have not completed 12 years, Lordship, 1/1/2006, I cannot claim. So I'm not claiming from 1/1/2006. I became entitled, Your Lordship, from 6/3/2006. I completed 12 years.
That is for the ACP.
For this ACP, Lordship. I completed 12 years in 6/3/2006. And this rate becomes applicable from 1/1/2006. So I become entitled from 6/3/2006. So if I'm entitled to that rate, Your Lordship, I should be given from 2006. But that was given to me only when I got my third MSCP in 6/3/16. So my prayer, Lordship, before this court is that I should have got this 4800 from 6/3/2006.
That's understood.
And not from 6/3/16, Lordship. They give me the MSCP, that is after another 10 years, in 6/3/16. They give me this 4800 from 2016. But my case is that, Lordship, when this 6 CPC came into effect from 1/1/2006, and I qualified that 12 years on 6/3/2006, I become entitled to 4800 from 6/3/2006, which has not been given, so I'm praying for that. That's the first leg. Then comes, Lordship, MACP. MACP, Your Lordship. Do I need to clarify with regard to this anything? So that's my limited prayer with regard to the first one. And with that only, Lordship, we had filed the writ petition in 2015. Subsequently, Lordship, after the filing, because this was pending adjudication, my MACP, Lordship, becomes due on 6/3/16. This is subsequent to the filing of the writ petition. That is why we had filed for amending that prayer and bringing on record that the subsequent development that I was due for my MACP from 6/3/16. 6/3/16, Lordship, I got my MACP. But that time, Lordship, I was given 4800. Now, my case is, Lordship, 4800 was due to me from 6/3/2006. From 6/3/2006 to 6/3/16, I should have got 4800, which was not given to me. I was given that earlier rate. Whereas they gave me 4800, Lordship, only on 6/3/16 when I got my MACP. My case, Lordship, is that then I become entitled to the next grade, Your Lordship, that is 6600. And that, Lordship, I have filed an additional affidavit where similarly situated employees like me have been given 666. That is the next grade, Your Lordship. So my case is that MACP, when it becomes due to me, 6/3/16, Your Lordship, From then on, instead of 4800 till when I retired, they gave me from 2016 till when I retired in 21, they gave me 4800. My prayer, Lordship, is that 48 should have been earlier from then to this, from 6/3/2006 to 6/3/2016, and from 6/3/2016 till when I retired in 21, Your Lordship, I should have got 6600.
So in 2016, you got 4800.
Till 2016, they continued to give me 4800.
After 6/3/2016 under the MSCP.
Sorry, Your Lordship is correct. From 6/3/2016, they gave me 4800. Prior to that, they were giving me an earlier scale.
When you should have got 6600.
When I should have got 60, that is the next one. Because my case is that, Lordship, 4800 is what they should have given me in the earlier round for those 10 years. And from 6/3/16 till I retired in 21, I am entitled to the next grade, Your Lordship, that is 6600. And that, Lordship, is evident from the, because similarly situated people have got this 66. So that I can just show Your Lordship in a second. Lordship, I filed an additional affidavit. It's there also, but here. Lordship, this is dated 13/10/2020, the additional. There are two additional affidavits. This one is 13/10/2020.
13/10?
2020.
It's not here. Oh, 13/10/2020
is an additional affidavit, Lordship.
Not the, it was the order. The additional affidavit was filed.
Sorry. The affidavit is dated in pursuant to the order dated 13/10. It's February 2022.
April, actually. Yes, this is 6/4/2022. That is your affidavit.
Lordship, may kindly come to page 4, annexure 1. What's the date? Note down, huh? Not for any.
Page 4.
Annexure 1, Lordship, is an order dated 15th November 2016.
That is page 5.
Lordship, there are two affidavits. I don't know whether Lordship is looking.
This is the order dated 15 November 2016. You're referring to that?
15 November 2016. Yes, Your Lordship.
Yes. Annexure 1.
Lordship will kindly see in column 2.
Yes.
Lordship, that is PL shown the petitioner before Your Lordship. Lordship, then benefits granted under 3rd MACP. Lordship has got it?
Yes.
Lordship, the scale is PB2 4800. Effective from 17/7/16. Effective from 17/7/16. Lordship, the next page, if Your Lordship is pleased to turn to. Lordship, this is another employee from the same institution, Lordship D. Chakravarti.
Yes.
3rd MACP.
Yes.
He gets 5400.
Yes.
So Lordship will kindly note the discrepancy. Now, in our main writ petition, Lordship,
This D. Chakravarti was also, he was, he joined on the same day as you.
no, he did not join on the same day as me, but the scale, Your Lordship, he is also getting it from 15, 12, 13.
But his designation is senior private secretary.
Lordship,
And yours is personal assistant.
Lordship will kindly go back to the clubbing of the grades.
Okay.
This is why I was I can go through all those, but I thought Your Lordship remembers. So
That is
because though it's not that only my people who are getting exactly my scale will get PB2. There are 3 different scales who are clubbed together
in PB2.
PB2.
Oh, he is also PB2.
He is also PB2. That is why D. Chakravarti, kindly see Lordship PB2. Kindly note that PB2. So my humble submission, there is a discrepancy, and this is further enunciated.
PB2 should be 4800 or 5400.
Lordship,
where does this 5400 comes from?
Lordship, I'll take your Lordship to that. 4800, then is 5400, then is 6600. These are the,
yes.
In that, these are the 3.
They are all clubbed together in PB2.
The 3 are clubbed together, which is 5,500, 5,800, 5,500, 9,000, 6,500, 10,500. These are the 3 scales, Lordship, clubbed together under PB2.
Yes.
Now, as I was saying, Lordship, there is a lot of bad blood between people who are lower in rank but placed and all that. To justify all that, the Government of India came up with this order dated 2010. 9/7/2010. That I'll come to later. Lordship, just on this discrepancy part, I'll then try to satisfy your Lordship. Then I'll come back to this part. So just at this stage, I will just explaining to your Lordship that the 3 which are available is now 4800, next one is 5400, and next one is 6600. So here I am showing your Lordship that D. Chakravarti was getting, he's PB2, but he's getting 5400. In our writ petition also, we've annexed your Lordship. Subsequently, the next page, your Lordship, that affidavit you're looking at, page 6. Same only, no? Page 6, annexure 3, your Lordship.
Should be page 7. I know in your file it is page 6, but here it is noted as page 7.
I'm sorry, your Lordship,
Annexure
it's some
3 is
correction.
page 7.
It's annexure 3, your Lordship. 9/11/21.
Yes.
Kindly rectify that. Lordship will kindly see that again different scales have been given. Dhiraj Chakravarti, your Lordship, the number 1.
Yes.
He's given 5400.
This is your RTI information.
Lordship.
Yeah.
This is given by Nehu. So one gets 5400. The other person, Dean Virginia Dingdo, 3rd MSCP, gets 6600. Lordship, here, because your Lordship was earlier referring to the post, your Lordship. So you will kindly see Virginia Dingdo is junior steno.
Yes.
Whereas I'm also, Lordship, when I joined as junior steno. But Virginia Dingdo is getting 6600 in 3rd MSCP.
Okay.
Whereas Miracle Shabong, private secretary, And Lordship, I joined as junior stenographer, but I became private secretary subsequently, Your Lordship. So I am also private secretary. Private secretary again gets 6600, whereas I get 4800. And this is information given by Nehu. So my humble submission, Your Lordship, is that I should also begin, because if similarly placed, similarly situated and holding the same post, Your Lordship, and being in the same scale, if they are being given 6/6, I should also get 6, because there cannot be discrepancy, Your Lordship, in this. So to sum it up in brief, Your Lordship, I have not gone through. If Your Lordship wants me, I'll refer to whichever is required. So the two things, Your Lordship, that from 1/1/2006, 6 CPC becomes effective. I am entitled to that from 6/3/2006. So from 6/3/2006, I should be put in that 4800, which I was not. I was given 4800 only when I got my MSCP in 6/3/2016 after 10 years. So for that, those 10 years, Lordship, I should be given the benefit, which is due to me. And from 6/3/16, Your Lordship, I come into the next grade. So the next one is 5400 and 6600. So 6600, if the others are getting, Lordship, I am also entitled to get 6600. So my prayer is, Lordship, from 6/3/16 till when I retired in 21, I am entitled to that. That's my case in brief, Your Lordship. I may be allowed to reply of my own learned principle.
Lordship. May it please, Your Lordships. No, I'll not repeat details about the schemes, because my Lord has in that Surajit Datta, my Lord, gone elaborately into those schemes. Very briefly, I'll say, my Lord, here, my Lord, three years are very questionable. 94. So for this petition is concerned, year 94, 2006 and 2016. Yes. Now, my Lord, admittedly, my Lord, central government provides for giving incentive or upgradations, my Lord, in case of stagnations. Where an employee do not have the scope, what my learned senior friend correct, my Lord, they are entitled for upgradations. Now, initially, my Lord, before the SCP came into force, now SCP, my Lord, will kindly note, came into force with effect from sometime August 1999. Before some other scheme were holding the field, here, my Lord, one-time upward movement, that was holding the field. Now, this is an admitted position, my Lord, I am not going into details. 94, what he was entitled, he got it. First financial upgradation, my Lord, he got it in 94. Now, 99, my Lord, SCP came into force. Now, SCP, as per the SCP, my Lord, 2 upgradations are available, but any upgradation already granted has to be adjusted, and this is after 12 years. Now, here, my Lord, counting from the first upgradation granted in 94, my Lord, after 12 years, that is month 6/3/2006, he was eligible for the second financial upgradation. He was granted, my Lord. Now, my Lord, the MSCP, my Lord, came into force, my Lord, with effect from, my Lord, 1/9/2009, Your Lordships. Now, here it is crucial. What my learned senior friends didn't know, it was notified by us in 2009, but it became operative with effect from 1/1/2006. That is wrong. MSCP become operational, my Lord, with effect from, it is there in the scheme itself, they have mentioned it categorically. I will take my Lord to the scheme. It is annexed with the writ petition, Your Lordship. Page 34, Your Lordship. 33, 34, Your Lordship. Of the amended writ petition. New writ petition.
Yes.
My Lord will kindly come to paragraph 9 at page 34.
Yes.
Any interpretation, clarification of doubt to the scope and meaning of the provision of MSCP shall be given by the department and person. The scheme would be operational with effect from 1/9/2008. Sorry, my Lord, not 9. In other words, financial upgradation as per the provision of SCP scheme would be granted till 31/8/2008. So these are the cutoff date. Till 31st, my Lord, 8/2008, SCP was holding the field. So he was not eligible to get, my Lord, whatever entitlement he was to be given under the SCP. And 6/3/2006, my Lord, what was holding the field? SCP was holding the field. So he was granted SCP. So it's not correct, my lord, that it came into effect from 1/1/2006.
Yes.
Now, my lord, as per MSCP, my lord,
Yes.
now it speaks about granting three financial upgradations in the whole careers. But whatever has been granted either under other scheme or under SCP has to be adjusted. Now, my lord, admittedly, this came into effect on 1/9/2008. Now, what is the situation, my lord? By this time, he has given already, admittedly, two financial upgradation, one under OTUM, one under SCP. So, my lord, the time gap, my lord, under the MSCP was 10 years between two financial upgradations. So, my lord, counting from 2006, the third and the final upgradation was available to him under MSCP 2016. Now, my lord, during the pendency, my learned friend considered that was granted. Now, only condition, so I will not go into it much. Only condition of my learned friend, she was not given, well, he was not given what actually he was entitled. Well, I'll take my law to resolve that confusion, my lord. I'll take my law to Nehu affidavit. We have annexed, my lord, what are the revision carried out, because whatever has been granted, that was under the 6th CPC, pay revision carried out under the 6th CPC, which came into effect from 1/1/2006. So, my lord, the relevant part we have annexed with our affidavit, Nehu's affidavit, my lord. But Nehu, of course, yeah.
Yes.
If your lordship, the relevant part I have annexed, my lord, that is the first schedule at page 32, annexure 7.
Page
32, my lord. Nehu affidavit.
This is your affidavit dated 6/8/15.
Yes. Lordship has got it, 6/8/15. No, July 15, my lord. July 2015. Lordship has got it.
Here is August. Anyway, that's beside the point.
It's a little bulky, my lord, little bulky.
Page, you are referring to page?
Page 74, my lord. 32, my lord. Annexure 7.
A7.
Lordship.
Yes.
Annexure 7, my lord. Now, my lord, Lordship will kindly come under the relevant pay scales. Lordship will start from 11, serial number 11.
Yes.
Serial number 11. Now, my lord, here I'll just clarify one thing, my lord. In 6/3/2006, when he was granted the second financial upgradations, he was, my lord, he was given this upgradation while he was drawing a salary of, my lord, pay scale of 5,500 to 9,000. That is at serial number 11, my lord, scale 10.
Yes.
Just immediately before, my lord, 6/3/2006, he was placed in the next higher pay scale of 6,500 to 10,500.
Just this one.
From the pay scale of 5,500 to 9,000.
At serial 11.
11, my lord. From 11, he was brought to, my lord, serial number 13 by granting the financial upgradation, and we are calling it second financial upgradations. So prior to second financial upgradation, my lord, he was drawing the pay scale of 5,500 to 9,000. No dispute on it. Now your lordship will see, my lord, what happened after the 6th CPC, my lord. This pay scale, my lord, at serial number 11, 12, 13, my lord, 11, 12 and 13, my lord, they have been revised to the pay scale, my lord, that is payment 2. Now they are called payment, my lord. Payment 2, your lordship will look. Now all these three, my lord, serial number 11, 12 and 13, my lord, I am concerned. 10, 11, 12. No, 10, 11, 12, 13.
13, 14, 15, 16.
No, my lord will come. 10, 11, I'll come, I'll make your lordship. I'll clarify this point, my lord. 10, 11, 12, 13.
Okay.
10, 11, 12, 13, my lord. Huh? This has been revised to payment 2, that is 9,300. to 34,800. Identical payment. All identical, your lordship will look into.
4200.
My lord. That is the, my lord, great pay.
Oh, great pay.
That is great pay.
Pay ban is?
Payment identical. For all these, my lord, 10, 11, 12, 13, this pay scale, similar,
Yes.
same payment, payment 2.
Yes.
Now your lordship will come and look into it, look into the grade pay.
Yes.
4,200. 4,200. That means ditto identical, my lord. That means if this man, if he was not given promotion, financial upgradation to that 6,500 to 10,500, even otherwise, my lord, he would have been in payment 2 and with the grade pay of 4,200. So here perhaps what is the pleaded case, my lord, I understand from the rate petition, MSCP made a provision, paragraph 5. You say in that kind of situation of merger, if the pay scale, if some financial upgradation granted, but subsequently it was found after a pay revision, this has merged into a similar single identical pay scale. Then he say you ignore that upgradation, give him a fresh. So here, my lord, going by this, obviously, my lord, if he was in 5,500, if it was not given also, my lord, after revision, my lord, he would have been in payment 2 and with great pay of 4,200. So actually no benefit as such had accrued to him. So this is the reason it should have been ignored. But they were developments. Subsequently, my lord, this was brought to the notice of the various departments, my lord. They have pointed out these anomalies or whatever your lordship to the Ministry of Finance, Government of India. Now, my lord, the Ministry of Finance, Government of India, my lord, has taken out, my lord, so far, my lord, this serial number 13 is concerned, scale 12, that is 6,500 to 10,500, which was granted to him by way of second financial upgradation before revision. This was taken out from the merger. After taking out for the mergers, Finance Department provided, my lord, now this pay scale will become payment 2, but grade pay will become, my lord, not 4,200, it will become 4,600. And I have annexed that, my lord. Annexure, my lord, Annexure 8. That is the next page, my lord, page 33.
Yes.
13 November 2009. Well, many things were written, the reasons and all, my lord. The operative part, your lordship will get it 34. Paragraph 3. My lord.
Yes.
Lordship has got it. I can read it, my lord.
Please.
Consequent upon notification of Rules 2008, Department of Expenditure has received a large number of references from administrative ministries, departments proposing upgradation of the post which were in pre-revised pay scale 6,500 to 10,500. That is, my lord, we are concerned with this here. As on 1/1/2006, by granting them grade pay of 4,600 in the pay band of 4.2. The matter has been considered and it has now been decided that the posts which were in the pre-revised pay scale of 6,500 to 10,500 as on 1/1/2006 and which were granted normal replacement pay structure pay grade of 4,200 in the pay band 2 will be granted a grade pay of 4,600 in the pay band 2 corresponding to the pre-revised pay scale of such and such with effect from such and such. Further, in terms of the aforementioned provision of the rules, in case the post already existed in the pre-revised pay scale, the post being upgraded from 6,500 should be merged with the post. So, my lord, by this, effectively it has been taken out from the merger. It's no more merge. Because his initial pay scale, my lord, from which he was placed in the higher pay scale by way of granting second financial upgradation, my lord, that is 5,000 to 9,000. And the second financial upgradation pre-revised 6,500 to 10,500, they were initially merged, payment 3 and the same grade pay. So no benefit was coming to it. But subsequently it was taken out by revising it to payment 2 with the higher grade pay of 4,600. So there is no question, my lord, granting him a higher grant him a fresh second, my lord, financial upgradations. So this is the reason, my lord, it has been correctly fixed. Now, your lordship, if I can take back, my lord, again to page 32,
Yes.
to peer revisions. Now, peer revision, my lord. Now, lordship is fully aware under the scheme.
You see, at the relevant point of time, before he was, given the MSCP, he was drawing the scale of 6,500 to 10,500.
My lord, I'm just coming back clear, my lord. Before, my lord, not under MSCP, because this benefit was given, his second financial upgradation, my lord, was under SCP.
Or SCP.
SCP. But of course, the pay scale, my lord, under, my lord, 6th pay, whatever I am referring to at page 32, because these came into effect from 1/1/2006. This is the pay revision, my lord. So, for the scheme is concerned, MSCP came into effect from, my lord, 1st September 2008. Prior to this, SCP was full. And he was given the second financial upgradation, my lord, with effect from 6/3/2006. So it had to be obviously under SCP, not under any other scheme. He was granted. So when he was granted, my lord, lordship will keep in mind, my lord, when he was granted, my lord, 6/3/2006, my lord, 6/3/2006, my lord, the 5th pay commission was, because this was notified later, my lord, the 6th pay commission, though it came into effect retrospectively from 1/1/2006, perhaps, my lord, 2008 or some point of time, my lord, it was notified. But when it was given, my lord, 5th pay commission was holding the field. So he was granted the second financial upgradation, my lord. So initially it merged under 6th CPC, but subsequently it has been taken out from the merger. So there is no question, my lord, of granting, my lord, any further higher pay scale. Now, your lordship, if I can, my lord, for understanding, my lord, appreciating the fact of this case, now, your lordship, my lord, I have referred to scale, my lord, 10, 11, 12, 13, merger. Now, subsequently, my lord, 13 has been taken out of merger. It became, my lord, 4,600, lordship.
Yes.
Now, my lord, in fact, 13 and 14, my lord, sorry. In fact, my lord, 12, 13, after it was taken out from the merger, my lord, 13 and 14, my lord, the pay scale has merged. Because if your lordship look into it, both will have now payment 2 and grade pay of 4,600. So, my lord, we are not concerned with this. Now, my lord, what is the, my lord, from that stage, my lord, what is the next higher pay scale? Lordship will kindly come 15.
Yes.
15, my lord, scale 14. Now, scale 14, my lord, is say payment 2, grade pay 4,800. That is the next in the hierarchy. And what the scheme say, you will have to give only what is next in the hierarchy, not beyond that. So next in the hierarchy, my lord, 4,600. Next in the hierarchy, 4,800. So in 16, we have given him 4,000. What is the grievance? What is the
16 you have given him?
4,800.
4,800.
That is the next available, my lord, financial upgradation available. Now we cannot, my lord, take a quantum jump and give him something else. But that is beyond our, my lord, power. Because we are strictly go by the scheme. And the scheme is very clear and categorical, my lord. It has to be the next in the hierarchy. So next in the hierarchy, my lord, 4,800. So my humble submission, my lord, this has been granted. It doesn't call for any interference. Now, other plank of submission of my learned friend, my lord, similarly situated. Lordship has already noted, my lord, assistant and senior stenographers. Well, how these are similar, my lord, unable to understand. And these people, some of them joined way back in 74, yeah, much before the petitioner, they have retired. I can, my lord, take back your lordship to her, because she has annexed it in her writ petition also.
As the additional affidavit?
Yes, my lord. 16,600.
Annex 3, page 7.
page number.
It's the RTI query, isn't it?
Yes, Lordship, payment 2 plus 5,400. Now, Your Lordship, my Lord, she has annexed certain documents. Now, my Lord, it's not page number. Lordship will kindly come to the second annexion. Dated 7th July 14. Now, he is referring to my Lord D. Chakraborty. He retired on much senior to him and returned his designation, Your Lordship will see. Senior Private Secretary. Senior Private Secretary, my Lord. He has been given payment 2 plus, my Lord. Payment 2 plus, my Lord, 5,400. So, my Lord, it's a different post. Seniority is different, my Lord. So, my Lord, saying that similarly situated and discrimination has been done, my Lord, is totally, my Lord, it cannot be taken into consideration. So, whatever has been entitled, my Lord, to the writ petitioner has been given, my Lord, in strict compliance with the, my Lord, requirement of the schemes. Because Lordship will see, my Lord, we are not central government. The employees are not central government employees, my Lord. These employees belong to, my Lord, autonomous body, Central University. And my Lord, normally whatever scheme is formulated by the Government of India, suo motu this has no application. This has to be examined by, my Lord, UGC. Now, UGC is University Grant Commission is our sponsoring authority. They will make modification, other thing, and then they extend it. And my Lord, I will conclude this, my Lord, because this scheme also, all the schemes, my Lord, unless these are formally extended, my Lord, of our own, we cannot implement. Because our sponsoring authority is UGC, my Lord. So I will take, my Lord, to that UGC's letter by which MSCP was extended to the university.
It's not disputed that
No, my Lord, the letter, Lordship is tone and tenure of the letter. Lordship will, it's not that. Just a scheme, central government scheme, suo motu it will apply. It's not that. My Lord, that letter is at Annexure 6, my Lord, page 41.
Annexure 6 of the petition.
Writ petition, amended writ petition. July 2010, my Lord.
Yes.
9 July, my Lord. So this is addressed to the university from the UGC, my Lord. I just read the Government of India, Ministry of Personnel Grievance, Pension, etc., issued central government employees scheme for the center. They are referring to it as meant for central government employees. The Ministry of Human Resource Development, Department of Higher Education, in consultation of Ministry of Finance, Department of Excellence, through its Integrated Finance Division, has conveyed the approval of the Government of India by letter dated for extension of the MSCP to the non-teaching employees of the central universities. So this is a fresh decision has been taken, my Lord, and that's how it has been extended. Now, Your Lordship will kindly come to 3. In view of the UGC above, UGC extend the MSCP scheme for non-teaching employees of central university. UGC maintain deemed to be universities. UGC maintain colleges affiliated to central university and the constituent college, etc. So now these are the conditions they have made. Where the issuer career progression scheme was applicable in this institution, the institution concerned must switch over to MSCPs. Where the earlier scheme, if any, adopted by the various, my Lord, this is not very relevant to Your Lordships. Lordship will come to the next page. Now, next page, my Lord, clause 9. Lordship will kindly come to clause 9. There shall be no deviation from MSCPs as notified by the central government. The guidelines issued by the Department of Personnel shall apply motatis and mutandis. So they have cautioned the same. There is no discretion which we can exercise. This has financial implication. The sponsoring authority is UGC, my Lord. So whatever we have given, my Lord, strictly as part of the MSCP schemes. So my Lord, my humble submission, it doesn't call for any.
Lordship, just one clarification which my learned friend has. I'm referring back to the document that he was playing reliance on, page 32, Lordship. of their affidavit in opposition. Nehu's affidavit in opposition.
Yes.
Lordship, under serial number 10, 11 and 12. 10, 11 and 13.
Excuse me. Yes.
Serial number 10, 11 and 13, Lordship,
Yes.
we are concerned with. 5,800, 5,500, 9,000 and 6,500, 10,500.
Yes.
Lordship.
9, 10, 11 and 12.
No, Lordship, the first column, serial number, that will be 10, 11 and 13. 10, 11 and 13 we are concerned with, Lordship. Now your 10, 11 and 13 because those corresponding pay scales, Lordship. Now Lordship will see that all three have been merged and put under PB2. That's clear. Lordship, and all these three are put in the corresponding grade pay of 420, 4200 in the column, Lordship. Now, Lordship, what my learned friend has said, it's correct. When I was given ACP upgradation, Your Lordship, before getting ACP upgradation, Lordship, when I got my OTAM, I was getting 5,500, 9,000. Lordship, that's the second one. That's as per column 11. And when I got my ACP, Your Lordship, that's a second financial upgradation, in 6/3/2006, Lordship, I was given 6,500, 10,500. Lordship. So, Lordship, that corresponds to 4,200. So, in other words, if there is no change subsequent to this, then from 6/3/2006.
But you see, subsequently, that has been changed to 4/6.
I'm coming to that. That's where the whole catch is, Lordship. That's exactly what I'm trying to explain. So, if supposing we ignore that for a second, then I'm entitled to only 4200, Lordship, as per this. Then I'm supposed to get 4200 from 6/3/2006 to 2016 when I get my MECP. But, Your Lordship, my learned friend refers to this Government of India Office Memorandum, where throughout the country there was unrest regarding this issue. And so they had to take out this 6,500, 10,500, which I was getting, and that is replaced by Lordship. The word is replaced by 4,600. Lordship will kindly note 4,600. So if I was supposed to get 4200 by this original one, because of unrest, because of withdrawing that and replacing it with 4600. So I should have continued to get 4600 up to 2016. But what happened in between, Lordship? When we were talking about this as on 2006, Your Lordship. But subsequently, Lordship, in between, there is something else which happened. The 6th pay revision came into effect. Lordship, here we are dealing with, as Your Lordship knows very well by now, that we are dealing with, one is financial upgradation, OTAM, ACP, MSCP. These are financial upgradations. And on the other line, we are dealing with pay revisions, where scales throughout the country are changed. When a new pay revision comes into effect, scales, whatever their entitlement is enhanced usually. So these two, though they are connected, but they are also not, it's not that we cannot mix up the two, Your Lordship. So when my learned friend says...
No, but see, what are you implying?
I'm implying, Your Lordship.
Are you saying that you have not been given the benefit of 4600?
Lordship, he says 4200 has been replaced with 4600. So I was being given 4600.
We refer from
'From whenever it was due, 6/3/2006
6/3/2006
up to 16 Lordship, I was given
4600.
4600 because that was changed.
Yes.
But to that extent, it is correct. But what happened thereafter, Your Lordship? After that, Your Lordship, the 6th pay revision came into effect. So when 6th pay revision came into effect, everybody's pay scale is changed. Mine also has to be changed because it is with retrospective effect.
Exactly.
Otherwise, why did the government say retrospective effect? It could have been effective from the date on which it is notified. The minute it is said that it is with retrospective effect, so everybody is entitled to get that benefit with retrospective effect from whenever it is due. So 6th pay commission is with retrospective effect from 1/1/2006. I am entitled from 6/3/2006. So I have to avail this Lordship. As per this Lordship, it becomes 4800, which has not been given to me. That's my limited case, Your Lordship. So my case is that because they are trying to say that I have given you 4200, you got 4600. That's an upgradation. No, that's not an upgradation. That was because of the unraised, it has been replaced. And second one, from 4600, 480, I am entitled because there is a pay revision. If there's a pay revision with retrospective effect, everybody is likely to get it. I should get it. My simple case is because of the pay revision with retrospective effect from 6306, I am supposed to get 4800. That's my case, Your Lordship.
So now you, as far as the MSCP is concerned, you'll be entitled to 5400.
5400 from 6/3/2016, Your Lordship, till I retired. But my case is, Lordship,
their case is that you should be entitled to only the 4800.
As per,
Understood.
I'm going by the, it's not something that I'm claiming out of the blue, Lordship, as per the pay revision, Your Lordship. Only case, Lordship, is that similarly, they are saying they are different. That, Lordship, I may be, if Your Lordship permits me, I'll try to get the dates on which their date of joining and when they got the MSCPs.
That is only...
No, here it is there that when they have got the 3rd MSCP. Regarding the 6/6.
That D. Chakrabarti in
the other two. Regarding that they're questioning that we are not similar. Because these notifications, Lordship, only show the date of 3rd MSCP. It's not showing when you've got your first, second. That will be relevant. As Your Lordship has rightly held that from at least from 6/3/16, I am entitled to 54, Lordship. That is admitted, that cannot be denied to me. That's as per the revision of pay scale, Lordship. But I'm saying that some others have also got 6/6. How they've got it, if they are getting it, then I'm also entitled. To show that, Lordship, that when they have got the MSCP, that I may be allowed to.
Which means that they have got it because of the corresponding change, when the 6th pay commission, came into
Lordship. That I'll try to satisfy Your Lordship only on that issue because I need some facts to bring on record for that. But 54, Lordship, is clear that 54 I am definitely entitled from 6/3/16 up to when I retired. Lordship, I think only difference we have at this stage is they are saying that they were giving me 4200 because of unrest, new notification replaced with 4600. Now, what is replaced with 4600 cannot be held to be a second upgradation, which they are saying that they cannot go beyond the government. It is not in their domain to sort of give it out of the blue. I'm not asking anything out of the blue. Because the first is because of the replacement, and then pay revision, 6th pay revision came into effect with retrospective effect from 1/1/2006. I become entitled from 6/3/2006. So I have to get that 48 as per that. Till 6/3/16. 6/3/16 till when I retired, the next one 5400. 6/6, Lordship, I'm claiming because others have got it, so I should get. That's my case in brief, Your Lordship.
Possible only thing you will not know. My London senior friend is referring to grade pay 4,200, 4,600 and 4,800. Well, these are all under the 6 CPC only. What I have referred and what I referred from there, these are all under 6 CPC, which became effective from 1/1/2006. Not any other. It's not the pre-revise. I have referred all 12.
But only with regard to the one I was holding, Lordship. 6,500, 10,500. The dispute was regarding to that. So that, as my learned friend has shown, that was taken up, and from 4200 it was replaced with 4600 throughout the country. So I got 460. So that was not an additional benefit given to me that because of this you've got one more. It's no. It's a replacement all throughout the country. I've also got that. So then,
see, 4600, yes, you're entitled from 16
true,
2006.
Lordship.
So you see, it stands to reason that as on 136 whatever
2006, huh?
63
Lordship.
2016, you should be entitled to the next grade, which is 4800.
My obliged, Lord.
Not the 54.
No,
because that is, you see, that corresponds to the change in the, when this 6 CPC came.
No, Your Lordship. If I may humbly submit, Your Lordship. The 6 CPC comes into effect from 1/1/2006. Lordship. With retrospective effect. So, till how 4200 I am entitled to get 4600, Lordship is very clear on that. Because of that replacement, I am getting 4600. Yes. After this happened, Lordship, then the 6th pay revision came in. This was subsequent to this.
That is the point of dispute. You are saying that subsequently the 6th pay, 6th revision came into being. He is saying that it was already invoked since 1/1/2006.
It was not in vogue, Lordship, because the notification is before Your Lordship. I've annexed it, Lordship. And my learned friend referred to it also. MACP did not come into effect from...
No, not the MACP. I'm talking about the 6th pay commission.
Lordship.
It was notified by sometime in maybe 7 or 8.
Yeah, that is...
Became retrospective effect from 1/1 to...
That's what I'm saying, Your Lordship. So, because of that retrospective effect, Lordship,
yes.
Definitely after this 4200 became 4600.
So that is clear.
That is clear, Lordship. After that, this pay revision has come. That is also not disputed by us. Pay revision is a subsequent event in point of time. So because of pay revision, Lordship, everybody's scale, whoever was getting gets changed. Who were getting 4200 would start to get 4600. Since I was getting 4600, I should get 4800 from 2006 to 16, Lordship.
That is exactly the point of dispute.
Lordship. Obliged, Lordship.
You have to convince this court as to how these things come to shape or being. I'm still unable to comprehend.
But since my lord has dealt with, at least my lordship is very familiar with those schemes.
In fact, my lord, the scheme as it is, I think there's no dispute over
Lordship. Scheme we cannot dispute.
What I have tried to show, my lord, briefly, was it taken out of the merger? It was taken out of the merger. If there is taken out of the merger, then my lordship will look into paragraph 5 of the MSCP, which says that if it merges with the original this thing after revision, then it should be ignored and a fresh financial benefit has to be given. Exactly. Because the reason...
So that is a replacement.
But then it has been replaced. My lord, so benefit is still there. So there is no question. Only thing he is entitled for the 3rd financial upgradation after 10. 16. I have shown, my lord, how it is. Next in the hierarchy is 4,800. So something else we cannot give. And in fact, your lordship...
That is under the 6 CPC.
6 CPC.
But what Ms. Paul is saying is the other way around.
My lord.
That 6 CPC came after the 4600 was,
No. This is all after 6 CPC. After 6 CPC was notified. That's why, my lord, I think...
No, I'll clarify that.
Lordship, 4,600. This is something provided by 6 CPC.
Yes.
It's not by anything else, my lord. And my lord, 4,200 subsequently taken out. These are all under 6 CPC. 6 CPC sometime, my lord, notified in 7 or 8, your lordship, effective from 1/1/2006. So all this submission we are making from, not from any other pay commission, my lord. 6 pay commission. 6 commission was holding field, my lord. I can give the exact date. 1/1/2006 till, your lordship, my lord, I think 31st December, my lord, 2015. Then the 7th pay commission, my lord, came into holds from 1/1/2016. So that period we are referring to, my lord, everything relates to 6 CPC. And in fact, your lordship, the second case, my lord, otherwise, did to say.
See, Ms. Paul, I think now what this court would be concerned with is when did this 6 CPC came into force? Of course, we have the date of 1/1/2006. But as far as your case is concerned, where does
When
it,
6 CPC came.
where does it fit into the that
Scheme of
schedule?
things, Lordship.
So if it is before that, after that, of course.
Before that, after that, but the fact remains, Your Lordship, it is with retrospective effect from 1/1/2006. That we cannot ignore.
That is, of course, that is.
So, supposing what my learned friends it's before after, that will clarify just now only, Lordship. The dates will give you, Lordship. But the fact remains when it is effective from. It is effective from 1/1/2006.
Yes, yes.
So, if it is effective from 1/1/2006, I am entitled to ACP, Your Lordship, from 6/3/2006. So, how can they deny me the benefits?
So as far as ACP is concerned,
Lordship.
you will be entitled to that 4600. As far as yours is 66.
Lordship, 4600 because of the replacement.
Forget
Because
about-
of the replacement.
Forget about the 4200. Now we are talking about the 4600.
Lordship. Then when this revision happens,
Yes.
4/6 I'm not getting because of revision, Lordship. Pay revision. 4/6 I'm getting because there was unrest.
Exactly. So
Lordship.
That is the.
So
that's the point.
so I'm getting 4/6 for argument's sake, Lordship. I'm getting 4/6, which I was actually getting till 2016. I'm getting 4/6. Can we now ignore the 6-pay revision recommendation? We cannot. I'm getting 4600 for all practical purposes. 6-pay revision commission comes into effect, says you are entitled to get this from 1/1/2006. I become entitled to it from 6/3/2006. So can they deny me? They cannot. This is central government money coming to me as per their scheme, Your Lordship. It has Nehu does not have to make any special provisions for me.
So far 4,600 is concerned, my lord. He was getting it from 6/3/2006. There
I
is no
admit.
denial of.
I
Now,
admit.
what more, my lord? At least I could not understand. Yeah. What more, my learned friend is saying? What she is entitled.
In the
I could not
meantime,
make out. Lordship.
according to the 6 CPC,
Lordship.
according to Ms. Paul, he should be entitled to 4800 as on 1/1/2006 or
6/3/2006. Grateful, Lordship.
That is.
But
That's a
the
case.
pay scale he was drawing, my lord, pre-revised, was not revised to 4,800. What it was revised to initially 4,200, subsequently taken out of the merger 4,600. So, my lord, that's why I have referred to that annexure, your lordship. On the left hand side, your lordships, pre-revised under 5th pay commission. On the right hand side, my lord, they have given the revised pay
I
scale.
think that's understood. What you can do is, as you usually do, just give a list of dates and.
Lordship, we'll do that.
And then the next case, my lord, I don't know, it is same.
Lordship,
Same
similar dates are different and
So you can just
these two.
file your written argument
for the second one also.
with corresponding
Lordship.
difference of dates and all those things.
3 and 4, Lordship, has the other 2 matters, Lordship. This has not been heard by your Lordship at all. So, Lordship, as per the notification, I think I leave it to your Lordship.
That you're talking about 2 and 3, isn't it?
2 and 3, Lordship, is being
these
heard
are
today.
part heard.
Regarding item number 6, where 2 other matters are listed, these are on a different footing altogether, Lordship, and this is we've not opened this file as yet. So, as per the notification, if your Lordship is pleased to take up or please
My
before
lord,
that.
one thing I'll say, my lord, even the remaining 2 cases, my lord, these all, my lord, hinging on these schemes,
No,
all arising out of this.
But going about by the notification as given by this, I leave it to your Lord. If your Lordship is pleased to, I have no hesitation.
No, but in fact,
I'm bound by.
no. In fact, your lordships, I was doing a case before Honorable Chief Justice. There, the Honorable Chief Justice said even the similar matters and where the court has applied its mind to some extent, this should not be brought.
Lordship,
before me.
I'll be more than
But
grateful
I have
if your
no
Lordship
problem.
is pleased to hear.
I have no problem. But only thing I'll say, my lord, lordship has spent a lot of time, my lord, on SCP, MSCP, OT,
Lordship.
all. Again, the same things will come. Same things. will
As your Lordship directs us.
come. I leave it to lordship.
I think this has to be clarified with the registry. Because since they have listed this matter before this court.
But then one thing, your lordship has clubbed them together, and somewhere in the merging all throughout it is appearing, my lord, the part heard. It is
No,
reflected
no,
also.
on the
if
last
that is
date,
with-
these two have been
no,
separated.
if that is the case, your lordship, and again I am saying these are involving the identical schemes. So, it's my lord. Anyway, my lord. I know.
Totally, I have no hesitation whatsoever. I'll be grateful, Lordship. In fact, if your Lordship hears it.
So we'll start. What do we do?
Lordship, as your if you want me to, I'll finish off with the second one, Your Lordship.
You said similar.
Similar, but Lordship, of course, there are few differences, Your Lordship. Obviously, because of few differences, is listed separately.
Fine.
Because this I have to finish 2, then go to the next one, definitely. So, Lordship will yes, hearing the other.
Clarify why I don't know. Orders. Sorry.
So, Lordship, the other 2 matters also being heard today, or
No, now we are going to the next number 4, isn't it?
okay? But I'm saying the other 2 are also being heard.
No, we'll confine as far as I think time will not permit us.
Okay.
As far as because I'll not be sitting in the second half. 2 I have a meeting.
What's the time? What's the time? 12:30.
Since there's not much, difference here, we can just go through and just point out what is necessary to be looked into.
Okay, I can give that written as your
want to,
Lordship.
If you want to.
I'll place that then. And if any clarification is required, Lordship will be available for making the clarification. Obliged, Lordship.
Heard then counsel of the parties. The hearing having been concluded, the parties have submitted that they may be allowed to file brief written synopsis of their argument. Do you have any authorities to cite?
Lordship, because it's on
Nothing much.
facts mostly.
Relying on the rules.
As paid for, this is matter after 2 weeks.
Obliged, Lordship.
So that is 3 and 4.
Lordship.
2 and 3, sorry.
2 and 3, Your Lordship. And item number 6, Your Lordship. If Your
Item
Lordship
number
is...
6, we'll take it up
Obliged.
another day. First, I'll have to check with the registry. I don't want
Obliged.
These are all.
But I'll be grateful if Your Lordship takes up because, as my learned friend says,
Yes,
we've
Lordship.
dealt with
Because
the
why, my lord,
schemes.
I'm trying to be practical. Lordship has recall that hearing of Surajit Datta, that took a long time, my lord. And entire MSCP, SCPM, now my lord is thorough, I think, about
Yes.
this.
So it becomes easier for us also to...
Why?
You're giving me too much credit.
No,
No,
Lordship.
absolutely, we are grateful for...
No, my lord. Lordship has, my lord, minutely gone through all those things.
Lordship,
So
I
now,
agree
my
with
lord,
my learned friend, absolutely. Because
let
it
it,
becomes
let it.
easier for us to argue
Yes,
also because
yes.
all that
Only
is
for
clear.
that. I have no under reservation, my lord. Because we cannot select anything, your lordship.
Lordship,
Only thing will
kindly
be
keep this
convenient.
next week, those 2 matters also next week. We'll make an effort to finish it off here, Your Lordship.
Okay, we'll look. We'll see about this. But then anyway, we'll post this matter on the
Yes,
same day.
yes.
Obliged, Lordship.
Obliged.
Because 6 hours, same day. No?
Obliged, Lordship.
Yes.
Item number 4.
Please, Your Lordship. I pray to let this matter be taken after a week, Lordship, because the arguing counsel is not keeping well, Lordship. He's not feeling well.
Here.
Yes,
My lord,
Lordship.
what he was informing that...
In fact, he was
having
ready,
some
Lordship. He
problem
has
with that.
some problem in his stomach, Lordship.
That's what he informed me also.
Accommodation has been sought for on account of the learned counsel for the petitioner being indisposed.
Lordship, kindly fix on. Can it be fixed on?
Fix it after 2 weeks because next week I'll not be here.
My lord.
As prayed for, let's this matter to 2 weeks.
Much more.
Obliged, my lord.
Item number 7.
Please, Lordship. Lordship, we will be filing the written submission, Your Lordship, in the course of the day.
Written submission?
Yes.
I've not even heard the matter. Has this matter been heard?
Your Lordship, on the last occasion, a gist of the matter has been heard.
Yes, Dr. Moziga.
My lord, this was a batch of 3 matters, my lord. One was disposed of on the last date because the accused person died, my lord, in the meeting.
Yes, so?
So 2 matters are still to be heard, my lord.
So 7 and 8 is still there.
Right.
But how do you say that written argument is to be filed when I have not even heard the matter?
Your Lordship, on the last occasion, my learned senior has prayed to file the written submission today, Your Lordship.
Filing of written submission will come only after the oral argument has been concluded. Yes, please start.
Your Lordship, this is a 482 matters, Your Lordship, where we are challenging the criminal proceeding initiated by the CBI. Your Lordship, here we are mainly challenging basically on two grounds, Your Lordship. Firstly, Your Lordship, that the FIR was registered based on a complaint made by one non-existing identity, Your Lordship, and which according to the CBI manual, Your Lordship, ought not to have been investigated upon. Your Lordship will have that on page 27, Your Lordship, and extra 10. Next 10, Your Lordship, page 27.
This is the complaint.
Yes, Your Lordship. Your Lordship, para 2, Your Lordship.
This one.
Your Lordship, may I read?
Yes, please.
The Commission has reviewed the matter and considering all aspects prescribed that no action should be taken on anonymous, pseudonymous complaint by Minister's Department Organization in line with its earlier instruction dated so-and-so, and such complaint should be filed Commission Circular of even number dated so-and-so stands withdrawn with immediate effect. And Your Lordship, the second ground, Your Lordship, is that the petitioner here in Your Lordship is not a public servant. Your Lordship, the petitioner herein was a research officer, Your Lordship, who receiving pay based on a consolidated pay, Your Lordship. He was employed as a research officer on a consolidated pay, Your Lordship, and he was not a public servant, Your Lordship. So, therefore, Your Lordship, he cannot be prosecuted for the offence under the PC Act, Your Lordship. The investigation agency itself, Your Lordship, has addressed the petitioner as a private person, Your Lordship.
Where is the fact that he is not a public servant?
Your Lordship, may have page 43, Your Lordship. Your Lordship, the investigation agency, Your Lordship, during investigation has addressed him as a private person, Your Lordship. Your Lordship, page 43. Your Lordship, the last paragraph, Your Lordship. Hence, the case is converted and the regular case is registered against Professor so-and-so, co-group member Dr. Sanjeeva Kumar Jha, co-group member Dr. Dhrubha Sharma, the research officer, Regional Center, Nehu, Shillong, private person, Your Lordship, within the bracket, Your Lordship. Yes, Your Lordship. Dr. Subhashish Das Gupta, at the then research officer, Regional Center, NEB, Nehu, Shillong, within this one private person, Your Lordship. And last one is Riniyanta Purkayastha, Administrative Officer, Regional Center, and AEB, Nehu, Shillong, within the bracket, private person. So, Your Lordship, they themselves has addressed the petitioner herein as a private person, Your Lordship. So, therefore, the petitioner herein is not a public servant, Your Lordship, and cannot be prosecuted for offence under the PC Act, Your Lordship. Your Lordship, here we are mainly challenging only on these two grounds, Your Lordship.
So 120B does not cover a private person. Or does it cover?
Doesn't cover. 120 is.
Your Lordship, here the CBI manual when during investigation has to strictly adhere to the CBI manual, Your Lordship. However, here the CBI has not followed its own manual, Your Lordship, and has gone against its own manual where it investigated the matter based on a pseudonymous complaint, Your Lordship.
The manual is the one you have referred to?
Your Lordship, may have annexure 16, Your Lordship, page 50. This is the manual, Your Lordship. 8.21, section 8.21 of the CBI manual. This is CBI guidelines, Your Lordship, the 8.21.
8.21.
Yes. May I read, Your Lordship? No action shall be taken on anonymous or synonymous complaint. Such complaint need not even be sent to the Ministry, Department, Public Sector undertaking concerned by CBI. It should be filed after entry in the complaint register. If there is any doubt about a signed or synonymous complaint, an inquiry may be held to the limit extent to check whether the signature is genuine and whether the signature admits having sent the complaint and stands by it. On such a check, if it is found that signature is genuine, further action should be taken on as the basis of a genuine signed complaint. Otherwise, no further action need be taken. However, information contained in such complaint may be used as intelligence input for identifying public servants indulging in corrupt activities, as well as in finding areas of corruption in various departments. Your Lordship, here the complainant, Your Lordship, on verification, Your Lordship, we could not find a complainant, Your Lordship. He does not exist.
Where is that?
Your Lordship, that is submission is in the petition, Your Lordship. Oh, Your Lordship, may have para 8 of the petition, Your Lordship. Para 8, my petition, Your Lordship.
Yes.
That your humble petitioner further begs to state that meanwhile the coordinator of the centre violated number so and so wrote to the Deputy Commissioner South Garo Hills and requested him to cause an inquiry verification to ascertain the veracity of the existence of the said NGO. And accordingly, the Superintendent of Police South Garo Hills got the matter investigated and submitted his report to the Deputy Commissioner South Garo Hills, Meghalaya, white letter dated so and so, stating that with reference to the subject cited above, I am to inform you that the matter has been carried out locally and confidentially about the existence of an NGO in Bagmara, and found that there is no such NGO by the name Nature People for Protection of Forest and Wildlife in Bagmara town area, and its program manager Shri Ratul Rabha could not be traced out in the address given by you. Your Lordship, the copy of the reports at Annexure 6. Annexure 6, page 22, Your Lordship. This is the complaint which was received from the CVC, Your Lordship.
Excuse me. So the complaint was filed by this
Yes, Your
NGO?
Lordship. Yes, Your Lordship. Which upon verification they could not trace NGO.
Where is the complaint?
Complaint is at page 16, Your Lordship. Annexure 2.
Yes. Please read out.
Subject prayer for your intervention for removal of corruption, nepotism, manipulation, and mockery in Ministry of Environment and Forest Gold Program at Regional Center, National Afforestation, Eco Development Board, and ABE, Shillong. We invite your attention regarding Ministry of Environment and Forest Program on Afforestation, Eco Development in Northeast India. Ministry set up its regional center in Meghalaya and at Shillong for facilitation of afforestation and eco development programs in Northeastern state. Regional Center of Afforestation, Eco Development is more than 25 years of existence in Northeast, has made no visible contribution. We are pained to say that it has become a means of shippening people's money in the pocket of a few who make corrupt nexus with the program coordinators and some officials in related office. Monopoly of coordinators and absence of true interest of controlling officers have transformed it in an office of favoritism on the foundation of casteism, kingship, nexus of corrupts, and ineffective functioning. We dot a few points to make a matter clear and convincing and draw your kind attention and request for necessary actions. The regional center is run continuously for more than 10 plus 10 equal to 20 years by a coordinator without any remarkable change in functioning. Usually there is a practice of rotation of an officer, head of an officer, or even ministry who is responsible for a program handling lakh crores of rupees each year. This brings improvement in functioning and transparency and practice in all organizations, NGO in India. In this office, there is no change for last 20 years because of favorable manipulation. Dr. Brajesh Tiwari is running the center continuously for longer 20 years as a core member with Dr. R. Tripathi and later as coordinated with core members S. Chaturvedi and S. Jha, an interesting combination of Tripathi, Tiwari and Chaturvedi Jha belonging to a particular caste. Your Lordship, here the charge sheet was filed mainly to only 3 accused, Your Lordship, whereas the prime accused, Your Lordship, they were letting go of the prime accused. Your Lordship, here the prime accused is the Dr. Brajesh Tiwari.
Charge sheet was not filed against him?
No, Your Lordship, only against 3 accused, Your Lordship, here. The main accused is not filed, Your Lordship. This shows, Your Lordship, that the FIR was filed by on malicious intent, Your Lordship.
I'm sorry, my lord, I just gone through the file. She's arguing with.
Your colleague is doing very well. Why would you interrupt her flow?
I'm so sorry. I thought she just started.
Yes, please continue.
Your Lordship, in the complaint specifically written the name of Professor Brajesh Kumari Tiwari and Dr. S. Chaturvedi, Your Lordship. However, for this main accused, Your Lordship, the charge sheet has not been filed. The main accused here, he is the coordinator of the project, Your Lordship.
Yes, Dr. Muzia.
My lord, look at the prayer of the petition, my lord. At page 12 of the petition, my lord.
Yes.
Well, the prayer is call for records of CBI case number so and so. Then it says, issue notice to the respondent to show cause as to why the CBI case number so and so and all its subsequent proceedings should not be quashed, and upon cause being shown and after hearing the parties be further pleased to quash the proceedings. So, my lord, they have come for quashing the proceedings, my lord, and in this is an admitted position that the charges have been framed, my lord. This is what they have stated in their petition, my lord.
Yes.
At para 21, my lord, the statement is that
Para 21 of?
para 21 of the petition, my lord.
Yes.
It says, my lord, that the petitioner humbly submits that the learned court below has framed charges against the petitioner on 25/9/18 and charges under section 420, 468, 471, so and so, read with 13(2) of the Prevention of Corruption Act on 25/9/18. My lord, my first submission, my lord, is that once charges have been framed, my lord, what is the proper remedy for them, my lord?
Yes.
It appears from the submission of my friend, my lord, that they are challenging the FIR at this stage, my lord. So, my lord, can FIR be challenged after charges have been framed, my lord? That's my first submission, my lord.
So, as far as the case is concerned,
My lord.
evidence is going on.
They are there in trial court. Evidence
Since
there?
charges have been framed,
Okay, Mr. Gautam will be able to. Charges framed since 18, my lord. Last 6 years.
So by now, I think some
proceedings must be
maybe
there, my lord.
2, 3, 4, or 5 witnesses. How many witnesses have you got?
Thirty-seven witnesses.
37.
37.
We should know how many witnesses are being examined.
Well, this is going to inquire, my lord. Second aspect, my lord, we have filed an affidavit, my lord, in this matter. But if I may take a look to para 4 of my affidavit. Just read few paragraphs, my lord.
Yes.
Para 4, my lord. That at the outset, I state that instant petition as filed by the petitioner for quashing of criminal proceedings in CBI case number so and so is totally misconceived and not maintainable both under facts and law. The petitioner invoked inherent powers of the Honorable Court under section 482 of the CRPC mainly on 2 grounds, that is, that the FIR, the investigation, the charge sheet against the petitioner has been submitted by the respondent CBI on the basis of pseudonymous complaint filed by one Sri Ratul Raba before the Central Vigilance Commission, which ought not to have been investigated into as per the circulars issued from time to time by CVC as well as the guidelines under the CBI manual. And number 2, that the petitioner is not a public servant under the Prevention of Corruption Act, as he was employed as a research officer on a consolidated pay and was under the payroll of the coordinator of the said project, and thus ought not to have been prosecuted under section 13(2) of the PC Act. I state that both the aforesaid grounds are factually incorrect and legally not sustainable, and the petitioner deserves to be dismissed. That I state that the real facts leading to the filing of the FIR, investigation of the case, and submission of charge sheet against the petitioner and other accused person are as under: the Central Bureau of Investigation, CBI Anti-Corruption Branch, Shillong Branch, registered a regular case number so and so on the basis of source information under section so and so. So my lord, our first submission is that it was not on the basis of pseudonymous complaint, my lord. It was on the basis of source information. The complaint was registered, my lord, and that your lordship will see from the charge sheet itself, my lord. Lordship kindly sees at page. Well, I'll just draw it.
Have you annexed the charge sheet here?
My lord, in the FIR, my lord, at page 20, lordship can see.
Page 20 of your
Page 20 of the affidavit, my lord.
Your affidavit.
My lord.
Yes, page
At
20.
page 20, serial number 6, my lord.
Serial number 6.
Complainant, informant, source.
So your source would definitely be that complaint, which you have tried to find out. Firstly, about the existence of that so-called NGO and the person who's
My lord,
who may have signed that that the complaint.
my lord, we do not know, my lord, because it appears in
Where
what,
is your source?
what is the
That
affidavit
is
we
the
said,
only
my lord.
source that you have.
In the next page, my lord, at subpara 2, my lord. The instant FIR of this case was registered on 28/10/15 by CBI ACB Shillong branch.
You reading?
Para 2 at page 3 of my affidavit.
Yes, para 2.
At page 3 of my affidavit, my lord. My affidavit.
Yes.
Yes, my lord. The instant FIR of this case was registered on 28/10/15 by CBI ACB Shillong branch on conclusion of preliminary inquiry number so and so, registered by CBI ACB Shillong branch on 26/2/15 into the allegations of this case. That preliminary inquiry was registered on the basis of source oral information received in CBI against unknown officers of Regional Center NAEB Nehu Shillong and unknown others for the suspected offence of misconduct. The copy of preliminary inquiry registration report is annexed as Annexure A, my lord. And at page 12, my lord, of the affidavit, same affidavit, my lord.
Yes.
The first sentence itself, my lord. Information has been received from reliable sources, alleging that the unknown officers of the Regional Center Shillong, in collusion with unknown others, had committed gross misconduct by unauthorizedly appointing as many as 5 research scholars, research fellows, and 5 supporting staff for the said regional center on regular payment of monthly remuneration in clear violation of the conditions laid down in so and so. My lord, From the affidavit what it appears, there was a separate source information. This is not on the basis of pseudonymous complaint only, my lord. Because the complaint is dated 2013, my lord. If your lordship kindly sees. My friend referred to the complaint, my lord.
Yes.
At page 16 of the petition, my lord. At page 18, your lordship will see the date is April 5, 2013.
Page 16.
It starts 16, my lord. At page 18 I was referring to, my lord. The last page of the complaint.
Yes. April 5.
April 5, 2013. And case was registered on 26/2/2015. So because of the time gap, my lord, is registered after about 1.5 years or near about 2 years, my lord. So it cannot be on the basis of that complaint, my lord.
Yes.
That is first submission, my lord. The second submission, my lord, from annexure 1 of the petition, my lord. This is the appointment letter of the petitioner, my lord, in Nehu.
Yes.
This is office order of 28 June 2012. It says, well, having accepted the post of research officer on a fixed monthly remuneration of rupees 20,000 without any other allowance or fringe benefits, Dr. Subhasis Dasgupta is hereby appointed as research officer up to the period so and so or until further order, whichever is earlier, as per the terms of conditions specified in the deed agreement entered into him and the regional center NAEB, Nehu, Shillong. This order stands effective from the date of so and so. And the appointment order is issued, my lord, by Regional Center, National Afforestation and Eco Development Board.
Coordinator of this.
Of this, my lord. And it says Ministry of Environment and Forest, Government of India. Now, my lord, in our affidavit, we have said, my lord, that he is a public servant, my lord, and he was performing public duty, my lord. My lord, for public duty, your lordship kindly sees the Act, my lord, Prevention of Corruption Act. Section 2, subclause B says, my lord. Witnesses. Witness examined. Mr. Gautam informed that 2 or 3 witnesses have been examined.
2 or 3, thereafter witnesses have not come. They have not brought the witnesses.
Have you got a copy of their deposition?
No, my lord, that is not there.
That would be material.
But if required, my lord, I can produce it to prosecute.
They can also produce.
Well, but section 2 B, my lord, public duty.
Section 2B, yes.
My lord. Public duty means a duty in the discharge of which the state, the public, or the community at large has an interest.
Yes.
And 2C defines public servant, my lord. 2C, lordship will see. To see subclause 8, my lord. Subclause 8, my lord. This definition of public servant means any person who holds an office by virtue of which he is authorized to or required to perform any public duty. So, my lord, our case is that he was performing public duty, so he'll come within the definition of public servant.
Why have you referred to him as a private person?
Well, that was at the time of registration of the preliminary inquiry, my lord. What my friend has referred, my lord, this is what at the time of registration of the preliminary complaint, my lord. After that, a regular case was registered, charge sheet has also been filed, my lord. So it is too late in the day, my lord. Well, that is at the time of registration of FIR, my lord. Page 43, my friend has referred. It says, my lord, hence the case number so and so is converted and a regular case is registered against Professor so and so, so and so, so and so, and there is some reference to as private person.
Yes.
But after that charge sheet has been filed, my lord, it has come out that they were in fact employees of Ministry of Environment and Forest, though on contract, my lord. Well, these are our main defenses which we have stated in the affidavit, my lord. I'll file a small written submission, my lord.
One aspect, if Lordship allows me, my lord. While Learned Senior has said that I was discharging public duty because I was a public servant. And on the same line, he also says that my appointment itself was illegal. Now, the main allegation here is against the coordinator. Now, my lord, interestingly, what has happened here, my lord, if Lordship will see, the synonymous complaint was also filed against the coordinator. Thereafter, during preliminary inquiry, also there were some findings against the coordinator. The coordinator is the one who supposedly appointed us illegal appointments. Now, my lord, if the appointment itself is illegal, whether I'll be called a public servant and whether I was discharging public duty will also have to be looked at, my lord. That is my submission, my lord. And as far as the time limit between the synonymous complaint and the PE is concerned, my lord, there was communication between the Central Vigilance Committee and the NEHU. My lord, that also I'll point out. Lordship, in fact, I was today supposed to file my written argument. My written argument is also complete, my lord. I'll place that before this court, my lord. These are just 2 points only. These are very interesting points, actually, my lord, when you look at it. And they do have a bearing, my lord. Because if we say that an illegal appointment is also a public servant, and that public servant discharged public duty on the basis of an appointment which they in the very beginning say is illegal. And all the while, my lord, they do not call me a private person at a time of registration of an FIR. CBI does preliminary inquiry. On the basis of the preliminary inquiry, they came to a finding I was a private person. At the end of the day, they could not file charge sheet against the main coordinator. So these 3 people, they have been unnecessarily been harassed, my lord. That is why I say it is an abuse of the process of law, and that is why I filed a petition under 482 before this Honorable High Court, my lord. That is my submission.
We'll file a written submission 2 weeks time. Both cases are identical.
Same, my lord.
Both the cases are
Same, identical.
Learned Counsel for the parties. It is the submission of the Learned Counsel that apart from the argument advanced before this court, a written argument will also be allowed to be filed. We are allowed. This is matter after 2 weeks.
Deeply.
Item number 13.
This is a Komora limestone matter, my lord, where a submission was made by them on the last occasion. The lease period has expired, my lord. So the matter has become infructuous. So they want to close the matter, my lord. My lord, here what happened, my lord, limestone mining lease was given to Komora somewhere near Sora side, that side.
Yes, for 30 years.
Now what happened, my lord, of the entire land, in one land there can only be one lease, my lord. Here what happened, my lord, when the mining department, government of India, when they came for inspection, my lord, what they found that some other people are also doing mining in the same land, for which mining lease was given to them, my lord.
By this company?
So by somebody, third party, my lord.
Third party.
Later on it transpired that the state government has given lease of their land, my lord, to somebody else also. So we suspended their mining license and other things, my lord. And in the meantime, while the matter is pending, this has become infructuous. Now, my lord, matter can be closed. We have no problem because they don't have any right to further renewal of mining lease. Only problem, my lord, for violation of the mining lease, my lord, we have filed criminal complaints against them, my lord. So closure of this matter will not have any bearing on those matters. My lord, that much observation will lordship kindly.
As far as that is concerned, see, criminal proceedings will take its own course.
Yes, my lord.
As far as this matter is concerned, by their own admission,
My lord.
it has become infructuous.
My lord.
On the basis of the fact that in the meantime that suspension, during the period of suspension, the lease has not been
expired.
Has expired.
So this matter has become only that order, because our concern, my lord, they'll place that order there, my lord, saying that the matter has become infructuous.
We have placed recently, Your Lordship.
Yes, this communication dated 23/8.
My lord.
23/8/2020.
Where's the relevant portion? 16.
Clause 16, my lord. 16.
Clause 16.
Heard Mr. L.M. Sangma, Learned Counsel for the petitioner, who has produced communication number, agreement number, dated 23/8/2018. The same being brought on record and marked as Annexure X. The Learned Counsel has submitted that in view of the remark at clause 16 of the said notification, said communication, wherein it is stated that I court next review and mining to support 16. Therefore, since the lease of the petitioner company has not been renewed in the meantime, irrespective of the fact that the said lease was under suspension, the
period of lease, my lord, expired
Period of lease
expired on 24/5/23.
The period of lease having expired on
24/5/2023.
This petition has therefore become infructuous. Dr. N. Musga, you are appearing for
all this one.
SDI?
1 to 3, sir. 1 to 3.
Appearing for respondent 1, 2, and 3, United of India, as well as Mr. K.P. Burchaji, G appearing for the respondents, state respondent, has submitted that though there is no objection to the prayer of the petitioner, it is to be noted that there are also proceedings against the petitioner company in criminal courts, and such proceeding may not be affected by any decision made by this court in this case. On consideration of the submission made, the prayer of the petitioners allowed, this petition is hereby dismissed as withdrawn on the same being rendered infructuous. Needless to say, any criminal proceeding contemplated or enforced against the petitioner company before any criminal court of competent jurisdiction would not be affected by any order pass in this case. Petition disposed of.
Item number 14.
Please, Lordship. As per the order dated 3rd 4th 2024, Your Lordship, we are supposed to get clarify the instruction, Your Lordship, where it says whether that.
Please, Your Lordship,
petitioner
it was fixed for hearing of the messages.
Sorry, Lordship,
only. I
just
am not-
let me just clarify as what the order says, whether it's required to implement the other new party. Now,
is
Your
not the
Lordship,
issue to
now, Your Lordship, may I just you take it? My learned friend, he says that they want to implement the new party where they say that he stated that actual NOCMA is not implemented as a party. But in the affidavit, he has filed the two miscase. He took miscase in the miscase number 109 and of 2022 and miscase number 1117 of 2022. In that miscase petition, he has in paras 4 and 6 of the miscase number 109 of 2022, he has clearly mentioned that he is the NOCMA and he is the NOCMA and as well as he is the villager. In the miscase number 17 of 2022, in para 5 and 12, he has categorically mentioned, may I take you to the miscase, say 117.7, miscase number 117 of 2022. Lordship. No. That is, we will come to that.
Miscase, my lord.
See, Lordship, that is the in
Just a
para,
second, just a second.
para 5, Lordship, para 5.
Just a second.
No, what I'm trying to claim, what I'm trying to say is, let me complete, then he can make a submission. Yes, he should not interrupt. In para 5, he has categorically stated, page 7, Lordship. In his miscase 117 of 2022, para 5, he is the applicant, he is the private respondent. In my miscase, he is the respondent number 6, and in this here, in the main case, he is the private respondent number 3. He said that applicant, in this, here he become applicant, this is his miscase. He said that applicant who is the NOCMA of the said Akung, along with the villagers of the said area, practice Jum cultivation on their land as they have cultivated, planted various crop, vegetable, fruit, etc., including ginger, watermelon, corn, rice, butter, gourd, the crop, etc., usually planted in the month of February and the same to be harvested in June, July, failing which crop shall be rendered useless, and the petitioner in his family as well as the entire village Akung suffer irreparable loss and damages. Now, this is the where he says that claiming that he is the NOCMA. In this, it is clear that he said he is the NOCMA. Now, in para 12, my lord, page 13, again he has stated, para 12, again he has stated that applicant who is the NOCMA of the said Akung, his family members, clan members, as well as the farmers and the villagers of the said area are facing unwarranted obstacle and hardship in their cultivating, harvesting their crop, vegetable, etc., without any reason or justification whatsoever. Now, I don't want to read it entire thing because he said on the affidavit, he said that he is not a NOCMA. But in this application, in his affidavit in opposition, he denied that he is the not NOCMA, somebody else is the NOCMA. But in this petition, he admittedly, in which I have read out, saying that he is a NOCMA. And again in miscase number 9 of 2022, he has filed 2 miscase. Whatever may be, Lordship, that in para 4 and 6, Lordship, 4 and 6, miscase 109 of 2022, para 4, Lordship. He said that applicant who is the NOCMA of the said Akung, along with the villagers of the said area, practice Jum cultivation on their land, and as they have cultivated, planted various crops, vegetable, fruit, etc., including ginger, watermelon, so and so, butternut. The said crop are usually planted in the month of February, in the same are to be harvested June, July, failing which the crops shall be rendered useless, and the petitioner, his family as well as the entire village are concerned suffer irreparable loss. Now, para 6 also, Lordship, page 9, just paragraph 6. Here also he has stated that he is the NOCMA. The applicant, who is the NOCMA as well as the farmer, the villagers of the said area are facing unwarranted obstacle and hardship in cultivating, harvesting their crop, vegetable, etc., without any reason or justification whatsoever. Moreover, to the misinterpretation of this honorable court order by concerned police personnel, applicant as well as the entire village Akeng are immensely suffering, and the same may lead to the deprivation of their source of food as well as their source of livelihood. As such, if the said order dated so and so is not modified.
You have proved your point. What you are trying to impress upon this court
Yes.
is the fact that though it has been submitted before this court that this respondent 3
Yes.
is not the NOCMA. Now somebody else has come in his place, but in his application, in
Yes.
this case, he has reiterated the fact
Yes.
that he is the NOCMA.
He is the NOCMA. And the other in the main.
So according to you,
Yes.
there is no question of impleading any
Yes, Lordship.
other person as NOCMA.
Yes, and moreover,
That is your point.
yes, that is the point. And secondly, Lordship, this application was filed in the year of 2015 for registration of NOCMA. I have filed it. The petitioner has filed for registration of NOCMA, bearing only to register the NOCMA as a NOCMA of Jamata Akeng, because that case of 17/7 Bitor has been already been settled long back in the 1969, and we were appointed as a NOCMA of the Jamata Akeng. That the long list of NOCMA was there.
That is going to the
Yes.
merits
Now,
of this.
my point is, Lordship, since at that point of time, when 2015, the first initial application was filed before the EM, the NOCMA should have filed that, where my learned friend is saying that somewhere other NOCMA is there, that he should come and file an objection to this application. But instead of somebody, he is claiming himself he is claiming two. One, he said that he is a NOCMA. In my affidavit in his affidavit to the main petition, he said that he is a NOCMA. He is not a NOCMA. He is only a TSA. But he has filed an objection application to my application for registration of NOCMA. That is where the case is. The initial case that started in the year of 2015, where I have filed an application to register as a NOCMA of Jamata Akeng after the death of the last recorded NOCMA, Jogen Sangma and his wife. Then after that, we filed an application only to register as a NOCMA of Jamata Akeng. Then the private respondent, he has filed an objection to it, and then at that time, the alleged NOCMA, which my learned friend is claiming, he opted not to file an objection, but instead of him, the present respondent, who is himself claiming NOCMA as well as the Cha of the Akeng land, Cha of the clan, he has filed an objection. Since now the question is whether at this moment, whether he can be implemented as a party, because they were, since from 2015, they were never they were not a party, and neither in the court of EM and the CM. Now basically this writ petition is filing against the order of the EM. So my only question is whether the law permit when he is not a party in the proceeding. That is my case, Your Lordship.
May I please, Your Lordship? If you're done.
Yes.
Well, to cut it short, it is up to him if he wants to implead or not to implead. It's up to him, my lord. He is the master of his case. I am not saying that he should implead or he should not implead. If he doesn't want to implead, he doesn't want to implead. He has to argue on what is. If he wants to implead, that is up to him, my lord. As far as we are concerned today, if Lordship is pleased to take up Miss Case 117 of 2022, my lord. 109 has already been disposed of, so we are not getting into that, my lord. Miss Case 117 of 2022. The matter was listed today only for this purpose, Lordship. Lordship has Miss Case number 117 of 2022.
I think time will not permit.
Lordship,
It will hardly take 5
Lordship,
minutes,
may I just interrupt?
Please,
Because
please,
last
let me
time,
finish. I let you finish. Now you cannot interrupt. Please.
No.
I think we will not be able to take up.
Because I'm requesting for if Lordship recollects from the last date, my lord. It was concerning. I'm only if Lordship is directly pleased to come to page 16 of my Miss Case, because there is a sense of urgency, my lord.
We'll take up the matter tomorrow. Eh?
Tomorrow, very well.
Lordship,
Earlier there was an indication that
No.
this court may not sit on tomorrow.
No, tomorrow only.
Lordship, very well. It may be, if I may request, it may be listed in the orders column, my lord, because by the time sometimes it
No, actually, otherwise, Lordship, this is not an urgent. According to me, this petition is not urgent because since the Miss case has been filed in the year of 2022, nothing is happening. Because as I submitted earlier, there is a one particular place or within the Gondengiri Akung, that is what I got instruction, and even I'm going to read the entire order. There is nothing wrong in the order. Nothing wrong in the order because the court has said.
Tomorrow we'll take up the matter.
Definitely, Lordship.
Taken up the orders, Well, it'll come in due course, but
Yes,
Party, National Council for the parties. The hearing will continue tomorrow. This is accordingly.
Much less, Lordship.